there's the proverb, I think, about living in interesting times that never seemed more apt. And we have with us this morning a team from Dillon Eustace. So we're going to take us through some of the practical legal implications around COVID. So I'll hand you over to Mark, Kelly, and John and Jamie. Folks, I'll give you the floor.
Great, and thanks very much, Joe. And you're all very welcome this morning to our panel session, which is entitled COVID-19 Legal Health Check. My name is Mark Thorne. I'm a partner in Dillon Eustace, where I specialise in the area of banking and capital markets. And also on the call or on the meeting this morning, Kelly O'Hara, who's a partner and head of our real estate division, John Doyle, who's a specialist in employment law but heads our litigation dispute resolution division, and Jamie Enzer, a partner in insolvency and corporate recovery. So in planning today's session, we thought what would be useful was to present to you a scenario involving a company which we'll call COVID Co, and which is facing a number of challenges against the backdrop of the pandemic and issues around its business. We're trying to do so in an interactive way, but probably trying to bring you some practical answers to some of the challenges that are being faced. So it's difficult to cover a lot of detail in the areas that we're trying to cover, but we'll focus on the key areas of property, employment law, and some finance and corporate recovery work. So if we can turn to the slide detailing our scenario. We only have 2 slides, so not too technical. So COVID Co is the typical SME. It has 30 employees, some of whom are non-office based sales personnel. It's headquartered in Dublin with a 25-year lease on its premises. It is borrowing from a pillar bank with a fixed charge over those facilities. So COVID has hit, and naturally its sales are down, and there are a number of challenges to be faced. So we move on to the next slide. We'll see what these challenges are. So all of our employees are currently working remotely. We've reached an oral agreement with our landlord to reduce the rent for a period of 2 months, but when that expires, then we'll be back to full rent. The bank repayments are up to date, but look difficult into the future unless we see a recovery. We've told our staff recently that they're due to return to work, but 2 of them have indicated they're not willing to do so. So against this backdrop of uncertainty, we may have an issue around redundancies. So as you can see, this is a typical company for which you're probably either advisors to or happen to be working in. And we're going to try to dissect this into a number of parts and address some of the more pertinent legal issues. So initially looking at the reopening of the office, if a company is reopening their office and they need to make alterations to the premises, maybe to create some additional divisions or something for social distancing. Kelly, can you give us some pointers from a property law perspective in terms of considerations?
Yes, thanks very much for that, Mark. Mark has mentioned that COVID Co occupies its premises under a lease, and just to state that most leases will contain provisions that prevent any alterations without landlord's consent, although some leases will permit internal non-structural alterations without having to go and get the landlord's approval. So the first thing that our COVID Co needs to do is check and see what its lease says relative to the works that it is proposing, and if landlord's consent is required, it should share its plans with the landlord and document consent, usually in the form of a license for works. But an important consideration as part of the planning and discussions with the landlord will be whether or not any statutory consents might be required for the works. And this is particularly important if any of the space is to be subdivided to create smaller floor plans, because that may well trigger the need for a new fire safety certificate and disability access certificate. And we are aware of issues that are arising with companies making their space smaller in this regard. And so it is critical that technical advice from an appropriate professional, such as an architect or fire safety consultant, should be taken in these circumstances.
Great, thanks, Kelly. And I think from a financing point of view, obviously the Minister and Sinead have referenced some of the credit facilities available, and there are also government grants such as the Restart Grant Plus, which provides direct grant aid to businesses with up to 250 employees to help them with the costs associated with reopening or re-employing workers following the COVID closure. So that's certainly something to be considered. We're not going to go into detail on those grants and credit schemes, because there's quite a lot of information available on governmental websites already in relation to those. So, but this is certainly something that's to be welcomed and certainly to be explored by the SME sector. John, from an employment perspective, we've told people they're coming back, but two of the employees have said that they don't want to return. So what's the position with respect to forcing them to return to the office?
Yeah, sure. Good morning, everybody. I suppose the first thing I would say as an introduction to all of the employment law aspects of this is that there are strict kind of legal positions that people can adopt, and then there's the softer kind of HR things. So you've got to bring your staff with you. So I think that should be an overriding principle for people to bear in mind. Before the company here could even think about forcing employees back to work, the first thing it'll have to do is to make sure that it has its own house in order. And by that, I mean that it has complied as fully as it can practically with the government's return to work safety protocols. There's a huge amount of information publicly available on how to achieve that. So that will be the first thing, to make sure that it has its own house in order. The next thing is that they need to be aware of what level we're at. Now, we know since midnight last night, thankfully, we're all on the same page, so I don't have to go through different levels. But level 3 requires that people only work they work from home unless their attendance in person is absolutely necessary. And that could be a bit of a debating point where employees are not happy to be coming into work. And it's going to be particularly difficult to say that somebody can't work from home if they've already been doing that for the last number of months quite successfully. So that is going to be an issue. If the employer forces or attempts to force people, this is going to potentially lead them into conflict. And you could have a situation, for example, where the employer uses a mechanism by saying, well, if you don't come back to work, I'm not going to pay you, or I'm going to put you on some sort of leave, unpaid leave. And if the employee disputes that, then the likelihood is that they may end up in the WRC. And the adjudication there, the key and the nub to that is going to be whether the employer can establish that the person's attendance in the office as opposed to at home was absolutely necessary. And that's going to be a very high bar for the next foreseeable stages 3, 4, or hopefully not 5. The best thing the employer can do to protect itself in these situations is to have a clear, written, flexible working policy. Now, it's not obliged to grant flexible working, but it is required and would be expected to give any request for flexible working due consideration. So in order to avoid claims that you're treating somebody unfairly or discriminatory, which is even worse, have and publish, so that everybody is aware of it, a flexible working policy. And I think that's the best protection in the circumstances.
Thanks, John. And I take it in terms of even thinking of forcing people back to work, is there a different situation if that person has an underlying condition?
Slightly different in that even with underlying conditions. So the HSA has 2 broad categories. Those are people who are at high risk and those who are at very high risk. And even for the very high risk people, there's no absolute prohibition on them going to work, but they are advised in the very high risk categories to contact an occupational health specialist to make sure that it's okay for them to go back. If you're high risk but not very high risk, then simply telling you to take extra precautions. So all of the things that we're already familiar with, the hand washing and distancing and all of that, that they take particular care. So there's no prohibition, but I think going back to what I said at the beginning about being reasonable and how people are treated and how treating one person is going to be seen by their colleagues, whether it's fair, right, proper, reasonable, they need to bear all these things in mind, but there's no strict prohibition on high risk people coming back to work.
Thanks, John. So assuming that we get a chance to get back to work and restrictions are eased or lifted, we're starting to get back to something approaching normal working practice. On an ongoing basis, Kelly, we currently only have an oral agreement in relation to rent reduction with our landlord. What are your thoughts on that?
Yeah, thanks, Mark. Well, to put it simply, oral agreements should be avoided. If our COVID co is going to do a new deal with its landlord in the longer term, it's really important that the agreement is documented and that legal advice is taken. Take the 2013 case relating to the Barge pub in Parliament Street in Dublin as an example. Long story short, during the last recession, the tenant of this pub agreed a very substantial rent reduction with its landlord of over 125,000 euros per annum back in April 2010. Now, unfortunately, the only record of this agreement was an email from the landlord's agent. And the email didn't mention, for example, how long the rent reduction was to last. In November 2012, the new landlord of the premises sought to reinstate the contractual rent. The tenant resisted, and the whole thing ended up in the High Court. Now, the landlord actually did make a very interesting argument at that time, and that was that the April 2010 arrangement wasn't legally enforceable because the landlord had not received any consideration or a quid pro quo from the tenant for the rent reduction. Such as, and we're seeing this in the marketplace at the moment, such as a tenant waiving a break option or agreeing to extend the term of its lease. And interestingly, the High Court agreed with the landlord on this point. But just to make the point that this legal flaw wouldn't have arisen if the parties had documented the agreement in writing and executed it under seal, because consideration isn't required in those circumstances. But that didn't happen in this case. But just to let you know, the tenant was ultimately successful, and the court did find that the landlord had made a commitment to the tenant. The tenant had relied upon that commitment, and the court held that the landlord was prevented in equity from withdrawing the rent reduction for so long as the tenant's business continued to be adversely affected by the prevailing economic conditions. But look, the moral of the story is that, you know, nobody wants to be in court, particularly in the High Court, arguing over technical legal arguments about equitable doctrines. And I think that the Barge pub case really does underscore the importance of taking the legal advice, documenting agreements in detail, in writing, and it is a lesson of what not to do at the moment.
Right, Kelly. I think that's something, a lesson learned from last time round, as it were. And I think also a further lesson is that deals that are struck with a landlord may also need approval of other interested parties. So if COVID Co has a guarantor in respect of its lease obligations, or indeed the landlord may need the consent of its bank in relation to any alleviation or other kind of amendments to the underlying lease. So that's something that needs to be considered from a banking perspective. And we know a lot of people are agreeing changes and alterations, but if the landlord refuses to agree a rent reduction, Kelly, what options can the tenant look to?
Yeah, so I suppose rule number one in this, and it's so basic that it's sometimes overlooked, but what does your actual lease say? Because there might be provisions in the lease that could be of real help at this point in time. And I thought I'd just give you a couple of examples. So number one, does the tenant have the benefit of an upcoming break option that it can either exercise to get out of the lease or use as leverage to negotiate a reduced rent? Just a word of warning though, with break options, if you or your clients do have the benefit of a break option that they want to exercise, they need to make sure that they follow the terms of the break option to the letter, because any breach of those terms will invalidate the break. Just on this point, I remember being approached during the last recession by a tenant of an industrial unit who were really keen to get out of their lease. They didn't need their premises, they were paying, the rent was too high, and they knew they had the benefit of a break option. But the difficulty was they approached me too late. The break date itself hadn't passed, but the date by which they had to serve the notice to actually trigger the break had passed. And in those circumstances, they had lost their right to break. Another important mechanism that might be of help in a lease at the moment are the rent review provisions, because there might be the possibility to review the rent downwards in the short term. Now, leases granted before the end of February 2010 are unlikely to be of help in this regard, because most of those leases will contain upwards only rent review provisions. But an awful lot of leases have been entered into since February 2010, and the rent review provisions should be checked to see if a downwards rent review is possible. And finally, COVID Co might also want to look at its lease to see if it permits the assigning or a subletting part of its space to another tenant in order to share the rental burden. Again, just to be clear, if your lease does not allow assignment or subletting of part, you can't compel a landlord to consider an application for consent to assign or sublet part. This is in contrast to a situation where at law, a tenant can ask a landlord to consider an assignment or sublease of the entire of the premises. But there are some mechanisms there, and that's just an example, because other leases may contain provisions that the tenant might be able to trade at this point in time.
Great, thanks, Kelly. So a key learning is to read the document if all else fails. But I suppose if we don't get to a position where we're going to agree a dispensation from the landlord, Jamie, from an insolvency perspective, we hear a lot about examinership being used as a tool to get out of leases. Is that a viable option in this particular instance?
Thanks, Mark. Well, I suppose disputes between tenants and landlords in the context of ownership do often grab headlines. Case in point being the consortium of landlords who are opposing the confirmation of the interim examiner's appointment to look. In terms of getting out of the lease, in the circumstances of this morning's case study, I suppose firstly, it's just worth mentioning that in this morning's situation, it would be distinguished from, for example, high-profile cases in, say, the retail sector that often get a fair amount of coverage. In those cases, those companies would have a number of outlets and want to use the examinership process to unburden themselves of unprofitable units, but all in support of a leaner and more profitable company trading forward. But in this case, it's the company's HQ. COVID Co is not looking to move. In fact, the proposal is that staff are going to soon come back into the office, having been working remotely. No doubt also envisaging some internal alterations because of COVID, which Kelly has spoken a little bit about. So I think in those circumstances, if the primary objective, or certainly one of the primary objectives for entering into examinership, is to negotiate a reduced rent, it can be something of a high-risk strategy, and I would just sound a word of caution. And that's because in examinership, the company itself, as opposed to the examiner, can bring an application to repudiate an onerous lease, but a court cannot confirm an examiner's restructuring plan that looks to unilaterally impose reduced rent on a landlord in an existing lease, whether during or out the other side of the examinership process, unless the landlord agrees in writing. Now, of course, it's also very much the case that we do see that the threat of repudiating a lease within the examinership process, or even the threat of liquidation, if the landlord's refusal to meet the tenant some way means an examiner cannot formulate a restructuring plan at all, that threat will result in the landlord agreeing more favorable terms. But I think the thing to always bear in mind is that at the end of the day, any landlord, as with the landlord in this case, will be making its own assessment as to whether reduced rent with the current tenant in examinership is a better option than going out to the market to look for a new tenant. But there are no guarantees that agreement will be reached. And as I said, critically, reduced rent cannot just be imposed. So just very quickly to give an example, I was involved in examinership reasonably recently, where for the business to survive as a going concern, it had to continue to trade out of its premises. And that was because the level of investment coming in wouldn't have allowed for deposit and the fit out of a new premises, as well as giving a reasonable dividends to creditors under the examiner's proposed scheme. But the landlord just refused to agree a new or amended lease. And that meant that ultimately the examiner, quite correctly, had to go back into court immediately once it became clear that no agreement could be reached with the landlord, to ask the court for court protection to be lifted. And then the company, obviously being insolvent, had to be placed into liquidation straight away. So, that was through no fault on the part of the examiner, whose efforts were in fact praised by the court. And in that case, the court even went as far as to note its dissatisfaction with the approach of the landlord. But at the end of the day, there was nothing really that either the examiner or the court could do about it.
Thanks, Jamie. And I suppose the position of landlords, being able to say absolutely no, maybe an element of watering down in that, Kelly. I believe late last week there was a new code of conduct published in this area.
Yes, Mark, it's pretty much hot off the presses. Last Thursday, on the 1st of October, the government published a code of conduct between landlords and tenants for commercial rents. And its stated purpose is to promote and reinforce good practice in landlord and tenant relationships as they deal with income shocks caused by the pandemic. The code is to apply until the 31st of July 2021. So the overarching purpose of this code is to encourage landlords and tenants to work together to help minimise the impact of COVID-19 on their businesses. It is a short code, it is only 7 pages long, and I think it is fair to say that it is very much a code of good practice, encouraging the sharing of relevant information between the parties. And I do know from speaking with fellow property professionals that the code in many ways would reflect what responsible and well-advised landlords and tenants are already doing in practice. An interesting element to this new code, though, is that it is trying to introduce a level of accountability. Under the code, if a landlord and a tenant are not able to come to an accommodation, it is not enough for the landlord to simply say no to the request. Under the code, it must actually provide a reasonable explanation to the tenant as to why it has refused the concession, taking into account the information that the tenant has shared with the landlord and the tenant's business plans and proposals and so forth, but also countering that with the landlord's own duties and financial commitments. But the very important point about this code of conduct is that it is a voluntary code and it has no statutory basis. And so it doesn't change the underlying legal relationship between a landlord and a tenant, or indeed any guarantor of the tenant. The code is just new. We don't know how it is going to work out in practice, but my own personal view is that it is likely to have an impact. And I think it will be interesting to see the extent to which the courts take into account whether parties have or have not complied with the code when landlord and tenant disputes end up in front of them.
Thanks, Kelly. So hopefully some, I suppose, a roadmap in a way to trying to get solution or agreement. But if the agreement doesn't end up being arrived at, what type of action would the tenant be facing from the landlord?
Well, look, just to state, a tenant cannot force a landlord to do a deal at the moment, even with the new code of conduct. And I think Jamie's case really illustrated that. And unlike the UK, there is no moratorium in Ireland at present on the termination of commercial leases for non-payment of rent. So the tenant could be looking at the landlord, maybe trying to cut its losses and seek to recover possession of the premises by way of forfeiting the lease. Now forfeiture is quite a technical subject, and time constraints don't allow a detailed discussion of it. But I just want to make a couple of points about forfeiture. Firstly, forfeiture is not necessarily going to be quick, cheap, or easy to achieve. The landlord has to undergo, in most circumstances, a strict statutory process, which involves serving notice on a tenant and giving the tenant the opportunity to mend its hand. Also, if a landlord can't obtain peaceable re-entry to a premises, then it must go to court to obtain a court order for possession. And then all tenants out there are entitled to statutory relief from forfeiture. And ultimately, courts are very slow to allow leases to be forfeited because it has such serious consequences and does result in the tenant ultimately losing its rights to occupy a premises. So forfeiture at the moment for landlords is not necessarily a panacea. And bearing all of this in mind, what we may see, and in fact we are seeing in certain cases, will be landlords approaching tenants direct, trying to do deals with them to perhaps take an early surrender of the premises, possibly in return for the tenant paying a reverse premium to recognise that it's getting out of its leasehold commitments early. Just as an aside on this, all of these deals have tax consequences, and it is important that the parties consider, for example, the VAT treatment of any payments that are made, and whether any figure that they come up with is a VAT income inclusive or exclusive figure. But again, going back to our case study and to touch on something that Jamie said, the old saying, be careful what you wish for, might apply if the landlord is successful in getting the premises back. Because in those circumstances, the landlord becomes fully responsible for the maintenance of the premises. It becomes responsible for paying the rates on the premises. At present, the rates waiver has expired. And as Jamie mentioned, the landlord will be faced with the very difficult task of reletting the premises in a challenging market. And these are some of the facts that the new code of conduct is also trying to underscore. But my final point on this, Mark, is simply that every case is unique and every case will very much turn on their own facts.
Right. Well, thanks, Kelly, and hoping that realistically, I suppose the capacity to reach agreement across the market, bearing the current circumstances in mind, we will see probably more deals than the last time around, given the more broad-based impact that this has had across the country and across the city, I suppose, in the context of people working remotely. So, hoping we do get a deal with the landlord. From an employment law perspective, John, we have a number of people working remotely, and even after restrictions are lifted, this has been a popular move for many employees. So assuming more are going to be working from home, what do the employers need to be conscious of in the context of home work?
Yeah, sure. Well, as everybody knows, we kind of went into an emergencies type situation at the beginning of all of this. So people grabbed laptops and whatever equipment they could find, and they set themselves up at home. And that was okay. And that was the way it was. Now, if this is becoming, and it has become already, sort of a medium-term situation, and we've already had inquiries from employers who are thinking of giving up their offices and making this a permanent or semi-permanent arrangement. So in that situation, it's vitally important for the employer to remember that while the employees are working from home, their home is a workplace. And accordingly, all of the normal statutory duties of care in relation to looking after the employee's health and safety apply. So essentially, in short, what the health and safety legislation requires of an employer is that it provides a safe system of work, and that involves a safe place of work, safe equipment, proper equipment, training, and so on, training and supervision. So the obvious difficulties that presents in relation to home working is that it's not feasible for the employer to go out and inspect everybody's workplace, which could be everything from a kitchen cupboard to a proper setup in a home office. There are online guides available, so people can be directed towards these ergonomic assessments. Ergonomic assessments can be carried out remotely, so over calls such as this, over Zoom, so the employer could retain somebody to advise employees. I think it's very important that there should be regular communication with employees, HR or management checking in to make sure that everybody is functioning okay. And apart from the mental health and contact and social contact, to make sure that they're physically set up properly, because that's the area which is more likely to result in a claim if, as a result of long-term working, somebody were to develop an injury. There's a lot of talk as to what approach the courts might take in the event of a claim where somebody's been working from home. And we just don't know yet, but I think it's reasonable to expect that the courts will take and allow employers a bit of leeway given the emergency situation, but that will wear off as things become longer term. So the employers now really need to, having got over the emergency couple of months, need to take a much closer look. And when you come to any type of a court situation, you're talking about evidence. So it'll be vitally important for the employer to have as much of what they have done recorded. So if they've sent emails to their employees, that's clearly a source of evidence. If HR have been telephoning people and asking them how they're getting on, that the records of those HR should be noting who they've spoken to and generally the gist of the conversation, to include any references to health and safety issues. Another related issue and very, very important issue is that of insurance. So it would be vitally important for this company or for any employer to get onto its insurance company immediately and check that its employer's liability policy covers employees while working from home. I think the general view of insurance companies was that it did for the short term, but again, as this becomes something which is more long term, that might change. The premiums might increase and so on. But certainly need to disclose to the insurance company that they have employees working from home. And a third thing that they might think about, not immediately coming to mind, would be data protection. So we all know that the Data Protection Commission is very hot in relation to data breaches, and it has considerable powers and can impose considerable fines on people where there are data breaches. So the employer or the company here in our test case should ensure that it has a very clear data protection policy. So checking with IT and its data protection officer, whoever the person is in the company in charge of that everything that can be done is done to protect people's data.
Right.
I think there probably are a few more I could outline, but for the time being, they're the three that occur to me.
Thanks, Sean. We're just conscious of timing there, so we might just stop at that one then. But I suppose we would hope not to be in a position to do so. But if redundancies are needed, what are the key takeaways in relation to that process?
Yes, this unfortunately is now a subject which queries are coming in on. The first thing I would just say specifically in relation to this company, there is something that employers need to be aware of if there are going to be several these major in any sort of a short period, and that's the provision in relation to collective redundancies. So depending on the numbers employed in the company and the number who may be made redundant, there is the potential for triggering the collective redundancy provisions. And if they are triggered, that involves notifying the minister that this is going to happen, also providing the minister with certain statutory information about the whole situation. And also importantly, it requires the employer to enter into a 30-day consultation period with the employees before they can issue any notices, and any notices issued before that 30-day period would be invalid. So in this particular case, because there are 30 employees, if this company were to make 5 or more people redundant within a 30-day period, they would trigger the collective redundancy provisions. And of course, they can avoid that if they time the redundancies appropriately and space them out. So it could be 2 or 3 people and then leave a 30-day period. I suppose in relation to redundancy generally, the really important thing to remember is that redundancy is an impersonal subject, and you can't, unfortunately, for some employers, you can't target certain individuals and just make them redundant. So it's a role that has to be made redundant, and the redundancy legislation requires that there be particular elements of change, and they're set out in the Act. And if you have sufficient change to justify the redundancy, then the next hurdle that you have to overcome is to establish that the selection process that you engaged in was objectively fair. And again, going back to the point about evidence, it should be documented and transparent. So the selection criteria have to be objective. So you have to avoid any expressions of opinion in relation to people and keep it back to things like length of service, qualifications, experience, ability to do multiple tasks, and so on. So to that extent, they need to make sure that the process is documented, clear, transparent, and fair above all.
Right. Thanks, John. So finally, I suppose, Jamie, turning to you, it's clear that our COVID Co is in some trouble, to say the least. If we need to make redundancies, then likely further cash flow impact in terms of meeting the company's obligations in that respect. So I suppose against the clock, if that's not too much of a challenge, and I suppose bearing in mind our audience of accountants who hopefully have, well, certainly those in practice may well have some insight on this. What should the directors be considering at this point in the context of solvency?
Yes, well, I suppose, in this case, unless COVID Co reach a long-term solution to its rent repayment capacity and restructures its bank debt, it will become insolvent, most likely in the early new year, I would have thought. And as you mentioned, redundancy payment obligations will put even more pressure on cash flow. We also don't know whether the company is up to date with revenue, for example. So in terms of what the directors should be considering, Well, I suppose firstly, I mean, the obvious immediate consideration is monitoring cash flow and the company's solvency in the short term, and that would include, maintaining realistic cash flow projections, holding regular board meetings, stress testing the rationale for making any payments to creditors at this time. Secondly, I mean, there is uncertainty as to whether the company can trade through its financial difficulty. So the company is in what's often referred to, certainly in a European law context, as pre-insolvency. And the Irish courts have, in adopting a pretty common sense approach, held that, in these circumstances, it's the creditor's money that's at immediate risk. So the directors, when carrying out their duties, which is still owed to the company, they must consider the interests of the creditors as paramount, and not place the interests of either the directors or the shareholders ahead of the interest of the creditors when exercising any decisions that the directors are making. The last consideration that comes to mind, and I think what is often the most challenging for directors, is the need to be making as realistic and objective an assessment as possible of the company's future and its restructuring options, and getting the appropriate advice on that. As a practical suggestion, the directors could, for example, consider getting an independent business review done. And look, I fully appreciate that money is obviously very tight in these situations, and that the cost of an IBR will, probably be pretty far down the priority list in terms of expenses that can be afforded. But I think nonetheless, it can be money very well spent for two reasons. I suppose, firstly, an external, critical, realistic review of the company's viability and its restructuring requirements is always worthwhile. For many companies that find themselves in financial situations similar to this one, the review, it can make for uncomfortable but often very necessary reading. And I think secondly, the IBR compared with half an eye on being turned into an independent expert's report pretty quickly. The IER is the independent report as to whether a company has a reasonable prospect of survival as a going concern, and the conditions to arriving at that view. And that, that's the statutory report that accompanies any examinership application. So, today's company, if it was in real life, it might have to move quite quickly with an examinership application. For example, if the bank appointed a receiver, the company would only have 3 business days to bring an examinership application. So having most of that work done and already paid for could be very worthwhile.
Thanks, Jamie. A whistle-stop tour. So I'm just conscious we're coming up against time, but hopefully some of the responses that we've tried to cover have a relevance to the types of questions that you're receiving or having to think about. And if I could just ask maybe each of John, Kelly and Jamie to give a short synopsis of key takeaways for their particular area. So Kelly, on real estate?
Yeah, very short summary, Mark, is that if landlords and tenants are encountering difficulties at the minute, they need to know what their leases say. So look at the lease, take legal advice, follow the new code of conduct, and if you are going to do a deal, make sure that it is carefully documented in writing.
Thanks, Kelly. I suppose from a banking and finance perspective, I think the key element, echoing Kelly's view, early discussions with the financing counterparties, make sure changes and waivers are documented carefully and that the financial consequences are discussed by the board at regular meetings, and make sure that covenants outside of pure repayment are considered in the context of any restructuring. We certainly found the last time around that the banking documents didn't contain half of what either the borrowers or the lenders thought they did. So it's certainly worthwhile reviewing them in detail. John?
Mark, I suppose the overriding principle in all of this is how an employer treats its employees is that of reasonableness and fairness. And I think if employees take it, or employers take that line, they should keep themselves out of most difficulties. And the next and final thing I'd say is keep a written record of everything. So publish written policies, and where you do engage and you do communicate and you do all the good stuff, don't waste your effort by failing to record it. So just have it as a backup. So fairness and written procedures.
Thanks, John. And Jamie?
Yeah, Mark, well, I suppose just a couple of takeaways from an insolvency perspective. I suppose the first one being that, examinership can be a really effective process to get out of leases of properties that are not fundamental to a company's survival as a going concern. as a process to renegotiate lease terms in a property that the company wants or needs to stay in, it can really put it up to the landlord, but it's far from certain that it will lead to the desired outcome from a tenant's point of view. But I suppose at the end of the day, if it's a choice between examinership and the chance of a successful restructure versus liquidation as the only other alternative, the risk will probably often be one worth taking. Conscious probably that this morning's audience will have heard this many times, but I think it's always worth repeating that in times of financial uncertainty, the directors continue to owe their duties to the company, but they must take the interests of their creditors into account in any decisions that they're making. And lastly, if a company is in doubtful solvency, getting an IBR done should be seriously considered. I mean, ideally from somebody who might be experienced in preparing independent experts' reports to court in examinership contexts, many of whom are institute members, that can be in turn turned into an IER very quickly, which would be needed if an examinership application had to be brought pretty quickly.
Great. Thanks, guys. Joe, just in terms of timing, you might give us some guidance on whether questions are...
We have a good few questions, but I think we've time for 2 if you guys can be really succinct. And I know I'm asking a lot of you there on this one. The first one, an employment question example scenario. Workforce is working remotely. While able to work from home, productivity, focus and attention to detail have deteriorated. If flexible working is offered, i.e. 2 days in the office, 3 days at home to minimize contact, but employee still refuses to go back to the office, there are no underlying health conditions. Can this be forced, or would an employee, or where would an employer stand in a scenario like this?
Okay, in a situation like that, I think where we're talking about people being able to work from home, and in the context of that question, I think they'd have to be implied into it, able to properly and adequately work from home. And that's going to be possibly an issue between the employer and the employee in this case. So it's always for the employer to require standards of performance. So we're all used to normal performance reviews. So if an employer can justify saying to the employee, I'm sorry, yes, you've been great and it's been brilliant while you've been working at home, but it's not, you're not now keeping up the standard. We can't go on like this indefinitely, and we require you to come back in to work on a particular basis. If that's reasonable and if that's fair, and the employer has consulted and spoken and done all the things I spoke about earlier, it should be in the best possible place to defend a claim, because ultimately, if the employee does not come back and point blank refuses, then it's a dismissal. It looks like it's heading for a termination. So reasonableness, record keeping, and ultimately it's entitled to have its own standard.
Great, John. Thank you very much. And one more from Barry Pryor. Is there a legal requirement for employers to reimburse employees working from home for light, heat, broadband, etc.?
No, there isn't, because generally speaking, where people are working from home, leaving COVID aside, before all this ever happened, that would be a matter for contract. So in your employment contract, everybody would know from the outset that you're working from home, and those things would probably be dealt with. So in the current situation, I know it has happened where employers have indicated to people that they will do that and they will give them a subvention. They've paid for desks, they've paid for chairs, and they've done various practical things like that, or sent out chairs to people. But no, there's no overriding legal imperative to do it, but there is probably a very strong HR imperative to be fair and reasonable with people.
Okay, thank you very much. I think we'll leave it there, guys. Listen, thank you very much for an interesting and thought-provoking presentation.